Hello, it's Matthew from the Average Gun Owner, and I'm here just to record a quick message that I think has been lost in terms of the most recent hearings with respect to the ATF director. Now, because we have so many new gun owners who may not understand the history of this, it's important to note why you're seeing a lot of memes and videos being posted in terms of the questioning of Mr. Chipman with respect to defining an assault weapon. So this is actually a very, very important issue. And the reason it's so important is there's historical context to this. So you hear people talk about, well, we need to ban assault weapons. And, you look at assault weapon bills that have been passed in certain states and on the federal level, but then you see similar looking firearms on the shelves, even in some of those states with just some features modified. And you wonder, well, this firearm is functionally in caliber and rate of fire no different than what they sell in the neighboring state. And that is true. And there are two reasons why people, when they're asked to define what an assault weapon is, why they can't. A, they don't understand firearms well enough to give a definition, which I think in this case, Chipman understands firearms enough. He's been in the ATF long enough. He understands the difference between an AR-15 and M4 and any other platform. But the second reason is this. They don't want to make the same mistake that they made when they tried to ban handguns. So for those of you who weren't around in the 1980s or were too young in the 1990s, may not realize that the initial push was to ban handguns. And back in the 80s, there was, this whole movement to ban what was called Saturday night specials. Now, they were small pistols that were claimed to be dangerous because they were made of inferior metals and technology. They were easier to conceal. They were cheap, so they could flood the market with them. And the mistake they made there was, that $1,300 SIG or the $4,000 M1911 from a custom maker were not a part of the conversation. And not only were they much more reliable, much more accurate, they were just as powerful, if not in a more powerful caliber. So what happened back in the day was there was a huge push on the federal level, and legislation was enacted and regulations were enacted to stop the import of certain inexpensive, smaller caliber handguns. Well, the problem they ran into was, by the time the Heller and McDonald cases reached the Supreme Court, the court had to decide the issue as to whether the ownership of a semi-automatic handgun was constitutionally protected. Those cases did involve, the typical handgun that people would own. As you know, revolvers are not nearly as popular as they once were, and single-action pistols, other than the 1911s, really aren't that popular, whether for self-defense, concealed carry, or otherwise. The standard bearer of handguns right now is the semi-automatic pistol. So the problem they ran into is, well, now they have the Supreme Court that didn't rule expressly on the fact that McDonald and Heller were able to own semi-automatics in particular, but those are the facts of the case, and that's the kind of pistol that they applied for. And the Supreme Court didn't say anything about that not being part of the holding, or we're not ruling on the fact that this type of pistol in particular can be protected. So people generally understand that that's what was intended, and if the case went back up, that's what would happen. Now we turn to rifles. So back in the day, in the 80s and 90s, the AR platform wasn't really that popular. Well, I should say it's not as popular as it is today. They were expensive. They weren't really commonly used for hunting because the 223 5.56 caliber is actually illegal in many states for hunting because it's underpowered for medium-sized game. But since there's been no direct ruling from the Supreme Court, and since they kind of missed the boat when it comes to handguns, they turned their attention to long guns and rifles. Now, mind you, rifles don't account for any more crime or murders today than they really did back in the 80s and 90s, definitely before the 1994 assault weapons ban. They weren't a significant source for crime, and they still aren't today. If you look at the FBI statistics, the numbers are usually in the 2 to 300 range of people who are murdered by the use of a long arm, and they don't break those down by AR-15 or even rifle or shotgun individually, it's all long arms together. So we really don't know what percentage of those are a semi-automatic rifle as opposed to a bolt action rifle or lever action or a slide action pump gun. So that's where we are today. So the main reason they're unable to define what an assault weapon is because they'll be pigeonholed into that definition. So if they now claim, well, it's just semi-automatic rifles of a certain caliber or higher, well, the problem with that definition is we'll just be purchasing and buying other types of actions and other types of rifles, and it's going to be a lot harder for them to argue down the road that that's now an assault weapon. So, this, what used to be considered a slippery slope, is the slope. It's basically, well, we banned this, now we want to go after the pump action shotgun. Which is funny that a lot of legislators say the pump action shotgun should be what citizens should be able to own. But a certain superpower during World War II actually petitioned, I think it was the Hague Convention, arguing that Americans shouldn't be able to use the pump action shotgun because it's much too devastating and destructive for use in modern warfare. So, I guess, what was argued as too devastating as a weapon during World War II, I'm now being told by certain people, well, that's the only weapon you should be able to own. And that is not an unusually dangerous weapon to own as a civilian. So, just to reiterate, it is very important, the terminology that's used, it's very important this particular nominee and his response to that question, because what he's basically doing is trying to leave the definition open so they can move to one type of platform, one type of firearm to another. Now, it looks like most people who oppose the Second Amendment just don't want you to own any self-loading firearms, mostly semi-automatics. I mean, you can have a lever action, you can have a bolt action, pump action, and some of those designs are almost just as fast as semi-automatic, or what's also known as an auto-loading firearm. But that's where they want to start, but that's not where they want to stop. So they want to be able to argue down the road, well, that lever action, if you ever watch any cowboy shooting competitions on YouTube, can be shot almost just as rapidly, and they want to leave it open to be able to go after that type of firearm next. So we could put aside the whole issue of what was the Second Amendment for. Was it really meant for defense only in the home? Was it meant to protect hunters to have the right to hunt? Or was it actually for the individual to own both for personal protection and protection against a tyrannical government? Putting that all aside, we don't even have to get there, because it's clear that the way they want to massage these definitions is solely based on keeping the issue open so that they don't make the mistake that they made with handguns, because now, even in Chicago, DC, and the rest of the country, you can basically buy a semi-automatic handgun in any state, and that is what they initially were trying to get banned. Now, another point in that respect is, as you know, a lot of states are trying to now ban magazine capacity for handguns, which for some older models literally makes them illegal or unlawful, because there are just certain models you can't get a 10 round or smaller magazine for. They were built wide body grips, they were built for a 15 round magazine or more, and they're not in production anymore. So if you own one of those older handguns, you can't get a replacement 10 round magazine for it. So that is why they've had to shift their focus when it comes to handguns to magazine capacity. They still want to ban that handgun. I think the Supreme Court and the district courts and the state courts have made it pretty clear that you have a constitutional right to own them. And this is the method by which they're going to try to limit your ability to purchase, possess, or continue to own even handguns. Whether it's for personal defense or concealed carry or defense against a tyrannical government. So there you have it. Just keep in mind when you hear any anti-Second Amendment or anti-personal firearm ownership individuals talk, just keep in mind the way they frame or refuse to answer the questions, because it says a lot about the fact that they're looking simply to keep the door open to ban as much as they possibly can. So again, Matthew from the Average Gun Owner, thank you for your time. I'll be posting more on this new channel. I'll try to keep it more geared towards new owners, what they need to know, where to get training, safety tips, and things of that nature. But I felt it was important to start off by posting on this one particular issue because this is something that seems to be the trend on how these types of issues are going to be argued and dealt with going forward.